Do you have constitutional questions? Get constitutional answers. We'll be answering your constitutional questions live, so get ready to call in now. Are you a prosecutor, law enforcement officer, or local government employee? Want to make sure you are executing the laws in a constitutional manner? Are you a city council member, township board member, or state legislator? Want to ensure the laws you pass are constitutional? Perhaps you're a citizen who wants to know the proper limits on government and the protections for your God-given liberties. Regardless of your role, call me, Constitutional Attorney Catherine Henry, with your constitutional questions during our live call-in show now at the phone number listed on the screen. And remember, together we can restore freedom.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Hello, everyone. I'm Constitutional Attorney Catherine Henry, and this is Restore Freedom Weekly. I'm so glad to have you joining us today. And hope that everybody can see and hear me, and once I get the go-ahead from everyone in the chat that you can see and hear me just fine, then I will keep rolling. Okay. I'm glad you guys are chatting with each other in the chat, but I need somebody to tell me that you can hear me just fine today. We always seem to have something wrong go with the technology, and I'm starting to think you guys can't hear me. Okay. Thank you, John. All right. So, like I said, hello and welcome. I'm Constitutional Attorney Catherine Henry, and if you are just joining me here for the first time today, welcome. You can see all things Restore Freedom all over the internet. Just by Googling Restore Freedom, you'll find us. You'll find our LinkedIn, our Facebook, Twitter, Telegram, my website. All of it will come up in the first page of searching. So go ahead and check it out now and click on some of those links to keep them at the top of the search bar. But today is your opportunity to call and ask me live any constitutional or legal questions that you have. And what you do need to know is that I'm licensed in a handful of jurisdictions. Honestly, I'd have to count them again, 5 or 6 right now. But I'm not licensed, obviously, in every single state or in every single federal court or things of that nature. I don't have a special IP. I can't practice patent law, things like that. Anyway, so I can't answer every single question, and most of the time, we don't want to get so far into specifics that it's really, going down the line of really giving you strict legal advice, rather than my point today is to point you in the right direction, to tell you what kind of an attorney you should be looking for, or to give you kind of that second opinion of does something sound right in a situation that you find yourself in. You have an attorney and there's just a situation you just want a sounding board, you want to ask a question about a particular situation, or maybe you are looking at potentially filing a lawsuit and you need to figure out what kind of lawsuit that might be, or maybe your best course of action to get you started. You're representing yourself and you have some general questions about the kinds of things you might need to look for if you have to file an appeal later on down the road, those kinds of things. That is what I'm here for. If I don't know something, I'm going to tell you I don't know it. So sometimes, and I thought that was a strength of mine, that maybe along the lines of humility, I'm not going to pretend I don't know something if I don't know it, but sometimes we have people who have given me a hard time in the chat or on the calls that if I say I don't know something and they push it and they push it and they push it and they just want me to give them an answer, but hey, if I don't know it, I don't know it. So it is what it is. But anyway, I'm going to go ahead and how on earth do I have a Stream Elements bot running? Well, that was a question we asked last week, and I still don't have an answer. So it seems to be new. If you guys that are normal in the chat or usual participants in the chat, if you can let me know. I think it was just the last show that showed up in our chat. I don't remember it showing up before, so I'm not sure at what point that would be a thing. But I just wanted to say hi to Jared and Nick and, of course, Lori, Amy, Jay Curvitt, Blue Line Transparency. Let's see, who else do we have? JC News Now. I wish it gave me a bigger screen so I didn't have such a tiny thing to scroll on. And there's probably more of you that have been commenting in there, but let me see. A lot of it was to each other. I just want to see. Okay, so we do have a question. Hey, this is a public service is joining us, at least with a listening ear today. So glad that you are joining us because I think you also would be interested in me answering the question that Blue Lane Transparency posed, which was the question on my Supreme Court mailgate. Oh, Mr. Handsome himself is joining us today. I wasn't sure if that was going to happen. So hello and welcome, Mr. Henry. All right, guys, what I'm going to do before I put that call number up on the screen is give you guys an answer to the question that has been posed, and that is an update on the case. So for those of you who don't know, because you might be new to the situation, I'm going to do my best to make it 30 seconds or less to tell you what the case is about, and then give you the update up to the point where I last posted on Facebook, because a lot of you are Facebook friends of mine. And then I'll give you the newest lowdown. So anyway, I promised my husband that when we moved down here, I wouldn't just come in like a bull in a china shop in the local politics scene and get super involved and start lawsuits and, speak at council meetings or commission meetings and, cause a ruckus for our family, because we just wanted to kind of ease into things. I have sued a city manager, that was 10 years ago, more than 10 years ago, I think, sued our city manager for violating my rights when I started speaking up at city council meetings about things that were done wrong, and then got active in local politics in a lot of other ways, ran for state rep after that, represented another city when they were getting rid of their atrocious city manager who liked to violate people's rights. And then for those of you who've known me since the 2020 era, I was the main voice in Michigan speaking out against the governor's executive orders and our dumbass Republican-controlled legislature at the time who sat on their laurels and let the governor do whatever she wanted to the people of the state of Michigan because they had no balls. So at any rate, I started making enemies and friends all over for that work. And so we were going to try to just ease into life here in Florida. Okay, I'm way over my 30 seconds. Anyway, what we did, though, was bought a very old house, and we started doing some upkeep, long overdue upkeep and things like that to the home, making it our permanent home. This is our permanent forever home. And 3 of the things that we did that are actually required under the city ordinances, the city has testified that they will never issue permits for those things. And they have, in fact, obtained a magistrate order requiring us to remove them, but we would need a permit in order to remove them, a permit that they've said they won't issue. And anyway, so the 3 things are our pavers that we have in the right next to our driveways. This used to be a duplex, and so there's 2 very tiny driveways, and we installed pavers next to those, between the driveways and the side property lines, so that we can park vehicles we can legally park all of our vehicles here, because without those, we actually can't legally park any vehicle at all on our own property, according to city code. And because of the minimum required widths for parking spaces, etc. We also put a privacy fence in our backyard, 6-foot privacy fence. And given that that's the backyard is where we have, a swing set and volleyball net and, stuff for our kids to play. And that's where, Emma and her teammates will practice during the week or on the weekends and whatever. We're required in the city ordinances to keep sound and light mitigated for neighboring residential properties. And so, hey, we did that. And then the other thing is 2 shipping containers, the smaller kind, that are that are in our like both of these would easily fit on a normal flatbed semi truck. Okay, and they're called brand new shipping containers. They've been used They're a one-trip shipping container that have been painted the exact same color as white as the fence, so they blend in. And 95% of people who are talking to me about the situation and who are standing right on the sidewalk of our small quarter acre parcel don't even recognize that the shipping containers are there until I point them out. And even then you can only really see one unless you're really trying to look for a different angle. At almost no point can you see both of them without a drone. Can you see both of them? You can only see one at a time, no matter where you are in the neighborhood. So anyway, with all that being said, the city started coming after us over 3 years ago, and I promptly alerted them to the illegal nature of them trying to single us out, considering a wide variety of things. There's equal protection issues, later developed when I realized what they were going for, Eighth Amendment issues, definitely excessive fines. All kinds of things. And the main thing that you need to know, because some people have said this to me, well, it sounds like so much of a hassle. Just walk away. Just take the loss and move on and fight bigger things. What you guys need to know is that they're coming after us and they want to take our house. There's currently a stay that has been issued by the circuit court, and that stay is prohibiting the city from entering the orders as liens onto our property. And so they want to put liens on our home, which will mess up our ability to have a mortgage and refinance and, all kinds of other issues, as well as they want to use those orders as levies against all of our personal property, to take our cars and all of our equipment, all of our things, all of our personal property, except for the clothes on our back. They want to take literally everything we own through liens and levies. And because they think that they can fine us into infinity, $75 a day. And according to their calculations, I think they would say we owe them at this point probably, $115,000. And then it just grows every day. So that's where we're at. Anyway, so we can't just let it go. Okay, this is big stuff. So where we're at is right from the initial hearing with the magistrate, which this is a public service, was there for. I appreciate that. I believe he was at all, if not most of all, of our hearings for this case. But anyway, so we had the hearing with the magistrate February 2023. And they started stuff with us almost 6 months prior to that. Labor Day weekend of 2022 is when they were starting stuff with us. And so anyway, we had the hearing in 2023 with the magistrate. We promptly filed an appeal. We get one direct appeal to the circuit court. We ended up winning partially. They were not allowed to physically come on our property and tear up all of our property and charge us for doing that. So we won that side of the appeal, but they were still allowed to order us to remove the things that are required to be here and then charge us infinite fines for not doing so. And so we then filed a petition for writ of certiorari to the Florida Court of Appeals. And the Court of Appeals, honestly, they played games with us. The clerk's office played a series of games. It was so ridiculous. They made me change and refile my petition 5 times. I ended up having a 4th amended petition. And the beginning was just a whole bunch of, the first like 3 or 4 of them was just ridiculous. The things that they were making me do. Well, you can't have pictures located in your brief. Well, I had pictures in my brief at the court below, and there's nothing in the court rules that says you can't do that. In fact, I even submitted documentation from other courts like the Michigan Bar Journal that encourages attorneys to put in graphs and pictures within the text of your brief to better paint the picture, because judges are only human, and having those visuals properly placed at the right places at the right times without being overused actually helps them go through the information and understand it better. So anyway, so it was stuff like that, okay? And then the latest time they made me redo it was Valentine's Day. that was the day I turned in the latest revision. And then in this summer, June, they decided to just dismiss my case, dismiss my petition for writ of certiorari. So saying, nope, just not going to handle this. You're stuck with the orders that you have below, which sucks, and it's not okay. And so I filed a request, a motion for rehearing, and a motion for a written opinion, because the order that dismissed it was it was 1 sentence, it was 1 sentence. Didn't say why. And because of that, check this out, Florida is the only state in the whole country where the Supreme Court has such a limited jurisdiction that in a situation such as this, the Florida Supreme Court literally has no jurisdiction. They cannot take the case if they wanted to. That's very important. That's going to have something to do with the latest round of updates. And I'm going to go into that. Actually, I'm going to tell you why I couldn't go to the Florida Supreme Court. Because of the court rule, Florida Rules of Appellate Procedure 9.030 A2A. That's the part that gives the discretionary jurisdiction for the Florida Supreme Court. And the only way they can get that jurisdiction in this situation is if some other court had certified this question as a matter of public importance, which hadn't happened here, or if the lower court, in this case, the Court of Appeals, had expressly construed a part of the Constitution, or they had declared a statute unconstitutional, or something of that nature. Okay, so there has to be some sort of express, meaning in writing, right? They had to give a written opinion about a statute or a constitutional provision. That's basically what I think there's 4 different options under the court rule. That's what they're talking about. And they didn't do that. Because they didn't put anything in writing, there was nothing done expressly. So all 4 options that I had under that court rule to give the Florida State Supreme Court jurisdiction, the Florida Court of Appeals robbed me of the opportunity to go to the higher court. I could not even petition them for a writ of certiorari. Now, because of that, and because our court rule is literally written in 1980 court commentary to the court rule, explains that because our state constitution was changed, it makes it so that for the vast majority of litigants, the Court of Appeals is the court of last resort for people in Florida, which is unlike every other state. Okay, usually it's the Supreme Court that's the court of last resort. Why is all this important? You're going to find out that piece in a minute. So what I did is I filed a petition for writ of certiorari with the United States Supreme Court, because you don't just go to, once you go to the state's highest court, which for us in this case, I went to the Court of Appeals. The only place you go then is the United States Supreme Court. And it's a whole nother ball of wax. I mean, I have to spend that petition, if they're going to grant it, I have to convince them it's a matter of national importance. That not only did the lower courts completely obliterate the Constitution, get everything wrong, but this is such an urgent thing, it's such an important matter that it's going to affect millions of other people, and it's the kind of issue that will reoccur, and it's something that needs to be handled. That's a huge burden. I mean, it's like infinitesimal, the amount of, the percentage that I'm actually going to be able to convince them of this. But hasn't even been the toughest part for me yet. I mean, writing it was hard, don't get me wrong. But I actually got it done before the deadline, like way before the deadline, which I thought was amazing because I never get done that quickly with writing a brief. And so this is what happened. It was due, the Supreme Court needed it by October 14th. And I thought, okay, well, as long as you have it mailed, right? The court rule talks about literally using USPS, not FedEx. They don't mention any other mail carrier services. They mention by court rule, Rule 29.2, if you're wanting to look it up later, the USPS. So as long as it is postmarked by the USPS by some sort of first class mail or priority mail type situation, then that is considered, like, that's the date. So as long as I mailed it by that date. So I e-filed all the documents because I'm also an attorney admitted to practice in the United States Supreme Court. I e-filed all the documents on the evening of the 29th, 12 hours before I went to the post office and mailed the paper documents. Now, when you e-file the documents in a brand new case, they tell you that they're going to hold them as pending, or actually what it's called is submitted, is what the status appears online. It's submitted, and they can't touch them until they get the paper documents, because the paper documents are the originals. And the way we did it was it required originals and 10 copies of everything, including the appendix. So we were talking about thousands of sheets of paper. This box was 26.7 pounds. Huge. Anyway, so it was supposed to be received by the post office on October 4th. I mean, it was supposed to be received by the Supreme Court by October 4th, right? It was mailed September 30th. And it arrived in Port Orange on October 1st. It then went to Lake Mary on October 1st. And then October 2nd at 12 a.m., 12:41 a.m., it arrived at the Seminole Orlando USPS Distribution Center. Orlando, okay? It's south side of Orlando. It's getting farther away from DC, but whatever. And it stayed there. And it stayed there, and it stayed there. And I was getting no updates. So October 6th, it then said, in transit to next facility, arriving late. Well, no shit, Sherlock, because it was due to arrive October 4th, and we're already getting this update October 6th. But even then, it didn't say where it was or, what date. October 8th, I called USPS to open an investigation. October 10th, I called the Supreme Court's office and left a message asking them to call you back, because you don't get a direct line. When you call the clerk's office, you have to leave a message, and they decide if and when they want to return your phone call. So I asked them to give me a call about the documents that may have been lost in the mail. They actually, this time, because I have had several calls that they've never actually returned, but this one, they, around 4:20 p.m. the same day, Michelle from the clerk's office returned my call, and I gave her all the information I had. She was actually super nice, wonderful to deal with. She said that sometimes things take much longer to reach them, and once it arrives, their safety and processing team takes a little while to review the packages before bringing them to the actual clerk's office, so they have some sort of warehouse or something. Because of this, she advised me to wait until Friday, October 17th before calling to check on the status. So I'm like, okay, I'm not very patient by nature, but I'm going to do my best at just sitting by, being patient, waiting for it to happen, right? In the meantime, though, October 14th, I received a call from USPS in Ormond Beach that the Seminole Orlando facility cannot find the package, because keep in mind I had that investigation open, and they think it was damaged. I was told I had to resend my package on October 14th. So October 15th, it was a Wednesday, I drop Emma off at her homeschool class that she has at a homeschool academy on Wednesdays, and I went to the post office that's nearby, and I talked to the person that was in charge of the investigation. And she confirmed that the box was still MIA and gave me information on how to file a claim. They would cover up to $100, which, what is that really? That doesn't even cover, it barely covers the postage. It doesn't cover the reprinting of it, whatever. By the way, they have they have denied my claim for the $100. So anyway, it's neither here nor there. So earlier that day, starting at 7 a.m., we started printing all new copies, right? Thousands of sheets of paper are required to be sent, and a bunch of them, hundreds of them in I want to say it's 518 copies, something like that. Over 500 copies of the appendices are required to be in color because the originals that were submitted to lower courts are in color. And then I had 2 pages in my petition that had color text that was helping to visually separate something that I was copying and pasting, quoting from the transcript from the city attorney and me, the dialogue between the two of us. And that'll come into play in a minute. But anyway, so only 2 copies of the pleadings, and all the rest of the color was in, original documents that were submitted, etc. Okay, so we print all the new color copies, get them all done. When we're done printing the color copies, virtually, I don't know, within half an hour of printing the color copies, I get a text that my box has arrived in Washington, D.C.'s post office with the expected delivery by 9 p.m. that day. Now, it did not say what condition the box was in, and keep in mind the last place to see it said it was damaged. So, October 16th, the very next day, at 11:30 a.m., USPS sent me an update that the box was picked up by someone. Picked up. According to the Supreme Court Clerk's Office, what they said in writing in the court rules and what they've told me, they don't pick things up. So I'm like, this seems shady, but whatever. And it was supposedly picked up at 8:08 a.m. the same day, okay, last Thursday, the same day. No, not last Thursday, 2 Thursdays ago, excuse me. At 12:30 p.m., I get a call from a different Supreme Court clerk and says, I see here that you attempted e-filing documents on a case well over 2 weeks ago. Did you ever mail the paper originals? And I'm like, whoa, first of all, I've already been talking to somebody about this a week ago, and she told me to call tomorrow. So, I was waiting for an update from you guys. But at this point, I was told that 4.5 hours ago, somebody picked it up from the post office. I have a hair that is tickling the side of my face. And it's driving me nuts. Anyway, so she said that she couldn't tell me if they were in possession of my box, but it's an actual off-site warehouse where that safety team looks through all the mail and everything. And I think that's back from the days of like anthrax threats and bombs in the mail and stuff like that. I think that's when they started implementing that, but I could be wrong. Anyway, so she said if they do have it, it would likely be docketed tomorrow, meaning Friday the 17th, or at least by Monday the 20th, okay? So on the 17th at 4 p.m., it had not been docketed. I had not received a phone call, so I called, and the phone rang and rang and rang and rang and literally never even gave me the option of leaving a message, and then it hung up on me. So I'm like, that's awesome. So I wait till Monday. Monday, I tried to file the claim for the $100, and their system immediately denied it. That was with USPS. Tuesday the 21st, at 10:10 a.m., I hadn't seen my documents docketed yet, so I called the clerk's office to ask for an update. I was able to leave a message, and I asked for a return phone call. Surprisingly, well, actually, no, not surprisingly, they didn't answer my phone call all day long. Okay, it was in the morning, 10 a.m. Didn't call me back the next day. So Thursday last week, 10:38 a.m., I had not received a return call from the clerk's office, and my documents had not been docketed, so I called and left another message asking for a return phone call. That was the last of the posting where I gave people an update. Now, here's where we get to what I haven't posted about yet. So Thursday around, I want to say, I don't know, sometime afternoon, between noon and 1. We'll just put it that way. Between noon and 1, I got a call from Michelle, who was the person, sorry, not from Michelle, from Angela, who was the person that called me the week prior and asked me if I had ever mailed my documents. That person called me. She returned my phone call, and I asked her if they had received my box. And she said, oh, yes, we received it last week. So they had had it for a whole week at that point, and nobody could bother telling me that they had it. So that was kind of frustrating. So I said, okay, but I'm confused. Why is it not docketed? And she said, well, they're looking into jurisdiction. She said, my supervisor is determining whether or not there's jurisdiction, and she's been looking into it, and I should have an update in a little while, so I will plan on I'll ask them, and I'll call you back later today. So I said, okay, sounds good. You know, I was pretty confident that the U.S. Supreme Court had jurisdiction. Otherwise, I wouldn't waste all the time and money. So, I get a call about an hour or so later. It was 2:15 p.m. I get a call, and she said, well, my supervisor has determined that the Florida Supreme Court has jurisdiction. Therefore, the United States Supreme Court does not have jurisdiction. We confirmed with the Florida Supreme Court that's the case. And so we're returning your whole box to you, and we are refusing to docket the case. And I said, wait, okay, so if you think there's no jurisdiction, you don't even docket the case? Because at every other court I've seen, they'll docket your e-filings or your filings, paper filings. They'll docket them, and then there might be an order of dismissal if there's a lack of jurisdiction. That's how it's supposed to be done. Seems to make sense. But nope, she said they won't even docket the case. So I'm like, oh, this is awesome. Okay. So I knew they were wrong, but I'm not going to argue with her, especially since she's not even the one that made the decision, right? So what do? I'm thinking, crap. My heart sank to the bottom of my gut. I'm like, this is ridiculous. My heart's just been ripped out of my chest. What do I do? And, I thought, well, if they're saying I have to file in Florida, it'd be way easier on me to file in Florida, or it would have been. Now I have to redo everything, but whatever. Because remember when I said to you, the U.S. Supreme Court, in order to convince them to take the case, first of all, I had to narrow down the issues significantly to only national issues, and only national issues of huge importance that I could convince the court that I had brought them up at every stage along the way, and each of them are so important to the United States as a whole, or at least to, many people, millions of people across the country. And so I don't have that burden if I'm going to the Florida State Supreme Court. But the problem is I only had, I believe off the top of my head, 30 days to file a petition for writ of certiorari with the Florida Supreme Court after the Florida Court of Appeals dismissed my case, or after they denied my motion for a rehearing. Although they still, in my mind, they didn't have jurisdiction, but if they did have jurisdiction, I only had the 30 days. So I'm like, okay, what do? I immediately called the Florida Supreme Court, and I'm thinking, crap, they're not going to give me an answer, because they'll say, oh, it's legal advice. We can't give you legal advice. You just have to talk to an attorney. I hate when they tell me that, because I'm always saying to them, I am a freaking attorney, but this doesn't make sense. So I called, and it was weird. It was like, for those of you old enough to understand what a party line is, it was like a party line. I was brought in on a party line where the clerk who answered could not hear me. She was already having another conversation with somebody else. I couldn't hear the other person, and she's carrying on and having this whole conversation, and I just kept going, hello, hello, hello. And eventually I was like, crap, this isn't working. So I just had to hang up, and I'm like, I'm going to call again and see what happens. And I called again, and a guy answers the phone. And I immediately explained to him the whole situation with the jurisdiction, and I didn't explain the whole box being lost and all that stuff to him, but I just explained the whole situation about jurisdiction and how the U.S. Supreme Court confirmed with somebody in his office that the Florida Supreme Court had jurisdiction. And I said, but my understanding... I said, my understanding was that, and I explained the whole thing as I explained it to you, how the Florida Supreme Court did not have jurisdiction because the Florida Court of Appeals did not enter a written opinion, so there was no express interpretation of a statute or constitutional provision under 9.030 A2A. And as soon as I was done saying all that, the guy on the other line said, wow, you've really done your homework. Just like that. And I was like, oh, okay. Yes, I have. And he asked me what my name was. And I said Catherine, and he asked me to spell it. And he goes, well, you spell your name right. And I laughed, and I'm like, yes, I do. And then he explained that his wife's name is also Catherine, and obviously she spells her name the same way that I do. So, things were getting off to the right start in this conversation. And so I explained in general my thoughts, and he said, yes, that would be correct. And I said, okay, that sounds great. Could you please look up my court file number? Could I give you my actual case file number? You look it up and you make sure that you are seeing the same thing. Is that possible? So he does 2024-915. If you guys want to look up my court file number with the Florida Court of Appeals, you could do that. Anyway, so he looks it up and he said, yes, you have done everything right here. You needed to file for that motion for rehearing and a motion for written opinion. They denied the motion for written opinion. He said that divested us of any jurisdiction. You are correct. The Florida Supreme Court has absolutely no jurisdiction to hear this case. And I said, oh my gosh. I mean, it was like a huge weight lifted off my shoulders. And I'm like, okay, this is wonderful. Now I need to convey this information to the United States Supreme Court. And I asked him if he'd be willing to have the conversation with the United States Supreme Court through this non-direct line. It's the only thing I had. And he said, yes, he'd be willing to do that. And I said, okay, great. I normally take down information of who I'm speaking with at the beginning of the call. I did not catch your name. What is your name? And he said, John, and his last name starts with a T. I can't remember the last name. But anyway, I said, okay, great. And I said, and what is your title there? And he said, I am the clerk of the Florida Supreme Court. What? He said, yes, I don't normally answer the phone, but the person who answers these kinds of questions was unable to answer, so I went ahead and jumped in. That was a God thing, guys. That is my testimony for today. That was a God thing. So, So I verified with him, again, he's looking up the actual court file. He is seeing I did everything right. He is confirming that I was correct, that Florida does not have jurisdiction over this case anymore. And he's saying he's willing to leave a message at the U.S. Supreme Court. So we both go to leave messages on the general line. And I'm stressed out because I'm like, they're sending my box to me, whatever. I'm talking to Mike about it, giving him the update, trying not to cry. I'm not a crier, but I mean, this is 3 freaking years long and they want to take everything we own. It is a lot. So I am extremely overwhelmed, crying to Mike on the phone, and I get this email. And Mike's confident. Mike's like, I'm sure, I know that they will give you a call back. I know it'll be fine. He's kind of right. So while I'm talking to him, I see this email come in my email. It's not one I can reply to. It's do not reply at UnitedStatesSupremeCourt.gov or something like that. But it's from Angela, because it's signed at the bottom, Angela. And it's her saying, this, we can't, we're closing out your case. We're denying your case because you should have brought, Florida has jurisdiction. We don't, blah, blah, blah. We don't have jurisdiction under this, United States code, blah, blah, blah. And then she signs it with her direct phone line. And I'm like, oh my goodness. Mike, I gotta go. There's a direct phone line. I gotta go. So I hang up with Mike. I call Angela and she answers. And I'm like, hey, this is Catherine Henry. I don't mean to beat a dead horse, but I just needed to touch base with you because I just got off the phone with the chief clerk of the Florida State Supreme Court, John T. And he confirmed for me that the Florida Supreme Court does not have jurisdiction over this case at all. And he said he was calling to leave a message at your office. Is there any way that I can have, I said, I got his direct phone line. Can you call him or have your supervisor call him directly? She said, yes, I'll do that. I said, okay. And she seemed really hesitant. She calls me back a few minutes later, and she didn't really say why, but it was kind of like maybe she couldn't get a hold of him or something. So I said, I'll call and I'll have him call you. Because at this point, she now knows I have her direct line. So I call him on his direct line, and he answers with, "Hello, Catherine?" And I'm like, "Yes." He said, "I thought that was your number calling." He said, "I have left them a very detailed message." And I said, "Well, I don't think she got that one, but I did get a direct line for her and spoke with her, and she's asked that you call her directly and she will transfer you to her supervisor. Would you be willing to do that?" And he said, "Absolutely." He said, "If you do not hear back from me, then we should be good to go." And I said, "Okay, that sounds fantastic. Thank you so much." By the way, I just have to say this guy was so amazing. In my very first phone call with him, he said on his own, this is normally something I would ask for, but he said on his own, "I'm going to find out who it was that gave the misinformation to the United States Supreme Court, because no one in my office should be giving that kind of misinformation. And based on what you have said to me and described it, there's no way that anybody should have told them that the Florida State Supreme Court had jurisdiction over this case." And I was like, okay, that's kind of cool. And I, was I going to believe it or not believe it? Whatever. That wasn't the main thing I was worried about. In this second phone call that I had with him, he said, "And by the way, I found out who it was. And I looked it up, there's only 3 guys that work in his office under him, so it's one of those 3. He said he is normally fantastic and very informed and very educated on the processes and things here. And so I'm going to have to talk to him and get to the bottom of this, because I don't understand why, but we're going to make sure that this does not ever happen again." And I'm like, that is amazing to hear how somebody in government, especially somebody in a position of authority, is going to do something to make sure mistakes don't happen again, to make sure their employees are doing what they're supposed to be doing and rights are not being violated. I mean, it's amazing, okay? So I just have to say that. So he and I hang up. He calls the Supreme Court. I don't hear. That's 2:15, right? I think by the time I get off the phone with him, it's 2:15. So I'm not hearing anything, and I'm trying to be patient, and I'm running around like still doing stuff. In fact, you can't quite tell with all the mess behind me, but I'm totally taking apart actually everything in our house and reorganizing and like spring cleaning, whatever. I've been super stressed, and we've never thoroughly gone through everything since we've been here. So anyway, I had my office all torn apart, and I'm trying to put it all back together, and I realize I'm outside at one of the shipping containers with some case files that are in there, and I was like, crap, I don't have my phone. And I ran back in, and anyway, so I'm carrying it with me the whole day. And by 5 o'clock, I'm like, I really shouldn't probably carry this with me, because the chances they're going to call me back are probably slim to none at this point. But 5:15, Angela calls me back. She said my boss was able to talk to John at the Supreme Court clerk's office and to confirm that the Florida State Supreme Court does not have jurisdiction of your case. I said, that's fantastic. She said, but they're still reviewing the case to see if the United States Supreme Court has jurisdiction. So that's where we're at right now. And I said, okay. I wanted to say, what the hell else do you need? But I just calmly and respectfully said, okay, that sounds like a wonderful update. Thank you. I said, do you happen to know if this might be tomorrow that they'll make the determination or what? And she said, well, we are on a rotating furlough basis, so I am not sure when that'll be. And I said, is this because of the shutdown? She said, yes. I said, okay, that makes sense. I have a realistic expectation then for time frame to look at. And so I heard nothing on Friday, of course, nothing Saturday or Sunday. Yesterday, I got an email that said, I'm going to pull it up here. Trying not to cry because it's been a lot. Where did it go? Okay. So at the top, the subject line is correspondence from the Supreme Court of the United States. And then it says, it's this long thing, right? There's like 7-8 paragraphs here. No more than that, probably 10 paragraphs. But it starts by saying, the above entitled petition for writ of certiorari was postmarked September 30th, 2025, and received October 17th, 2025. The papers are returned for the following reasons. The motion for leave to proceed in form of papyrus and the notarized affidavit or declaration do not comply with Rule 39 in that the motion and financial affidavit must be signed by both Catherine and Michael. So she and I had talked on the phone previously, before they were booting my case altogether, that Mike and I both needed to sign it, even if it's just the electronic signature. And I wasn't even thinking about that because the paper copy is what they go with. And the paper copy, I put my original signature on because I thought that's what they would need. When we e-file everything, I was just doing /s/ and whatever. But anyway, apparently I did that wrong. And actually, I take that back. When I e-file stuff, depending on what it is, I have my PDF program does a signature where date and time stamps it and the whole 9 yards. And that's, I think, what I did. So Mike's signature did not make it on some of the documents. It made it on the petition with the /s/ and then typing Mike and Catherine Henry. But anyway, so she was returning it for the signature pages. And then she said, alternatively, if we're proceeding where I am representing Mike, I would still be pro se. It's so confusing. I don't know why they're making it a thing. But because I'm admitted to practice law in the United States Supreme Court, she's saying that I cannot say that the petitioners are proceeding pro se, which is strange because I would still be representing myself. I literally technically would still be pro se. He wouldn't be pro se anymore because his wife is representing him. But me, I would be pro se. So it's super frustrating. Whatever. But that's what they're returning things for. They're also saying that the cover, they're saying I did it wrong. They're saying I did the title, the caption wrong, which is super complicated BS, whatever. She told me how she wanted me to do it. And then she said that I can't have any color in the petition. And I told you I had those 2 pages of transcript testimony or questioning and answering between the city attorney and me. I had them in 2 different colors, orange and blue, so it was easy to see who was saying what. And they said that it needed to be in black. So I have to fix that. And then so it says the electronic filing is hereby rejected. But I could fix all of it. Oh, and the other thing is my affidavit that went along with my informa papyrus. I swear there's a court rule, or I read somewhere in there that you're not supposed to have that information uploaded to e-file. But she said, nope, that's made part of public record too. So I'm like, that's awesome. So anyway, I have to make these changes and then, resubmit them. So I have 60 days to do it. And I have to reserve the city with it and all that. So what she's saying without saying it is that they recognize the United States Supreme Court has jurisdiction over this case. And they want me to change 2 pages in the petition and the cover sheets. The signature blocks and the cover sheets. I'm guessing this will take me less than an hour. It might even take me 10 minutes to fix all of the way we signed it and just type S/S and then take out the part that says we're appearing pro se and change it to I'm representing both of us. That's what she wants me to fix. And turn the color into black and white on those 2 pages. But she's sending the whole 26.7-pound box back to me. I asked her if she could at least keep the appendices. Because the appendices, like I mentioned, are hundreds of pages each. 11 copies, an original and 10 copies. So 11 copies. That's a lot. So I get to go through this all over again. But that's where we're at. So I am thankful that God gave me a bit of encouragement in the form of John, the Florida State Supreme Court clerk, unequivocally telling me that I got every part of my understanding of the court rules and jurisdiction and the procedures 100% correct, and that somebody in his office is the one that got it wrong, and that the United States Supreme Court has finally acquiesced to the fact that I was correct about the jurisdiction. It's just, all these things are so overwhelming, right? I've never taken a case by myself all the way to the Supreme Court. All the cases that I've participated in with the Supreme Court were with the Great Lakes Justice Center. And I didn't do that part of it. I didn't do the filing. I wrote the meat. I wrote the internal parts of the briefs, and I skimmed through them to correct how they did citation. They had errors in the ways they were doing citations, because we each had our own parts of the briefs. Anyway, Lori says, great question. And that means I have to scroll back up to see where there might be questions. So my bad. So I'm scrolling and I'm sweating. It's like 60 degrees or whatever, 70 degrees here, something like that. And I'm sweating in my office. Should have left my window open. I don't know why I shut it. Okay, I'm not seeing questions. What? I did not mean to say it was still a duplex. I don't know how I came across that. It used to be a duplex. It's not a duplex now. It's a single family home. It's been a single family home for years. Hey, Liberty Warrior. Yes, they are totally corrupt and incompetent. Okay, so I am scrolling for the word question to see if I missed where I missed. There's at least one question. I got all the way. Okay, it's because he didn't put the word question. Okay, I see it. Can you tell us what the compelling national interest is, or does that have to stay a secret? I can. Quite honestly, I'm so overwhelmed right now. I have to pull up my petition. Have it right here. Ooh, okay. And what I have to change is the little footnote here about where I say I'm admitted. I don't know how to hold this up to the camera. Where I'm admitted, we're appearing pro se, but I'm admitted as a member of the bar. I have to change that. That's why they're sending it back. Oh, and I'll show you the 2 pages that are in color. The horrible crime it is that I committed. Oh, I can't even do that because this is the black and white copy. But it's this little, you can see the indent part right there, and then it continues on the next page. That's in color on another copy. So, anyway. So the questions, well, it's kind of complicated, but let me tell you, because you kind of break it down throughout. So, I have to put in there what the questions are that I'm presenting to the court. And then, you do a bunch of things, but later on, you give the reason of why this case is the perfect vehicle to address the issues. And then then throughout each part of the brief, you explain why that particular question that's presented is important. So I'll tell you what the 4 questions are. And I will admit, in the last 150 cases that the court has accepted jurisdiction on, none of them have had 4 questions. I think the most I saw was 3 questions. 2 of them that came to the court on direct appeal for capital murder cases had 4 questions. Other than that, the vast majority of them present 1 question, sometimes 2. That's a lot more rare. 3, I think there were like 1 or 2 cases that presented 3. But I presented 4. My first question that I presented was whether, in a class of 1 equal protection claim, right? So I'm not saying the city is discriminating against us based on me being blonde or of Finnish heritage or transplants from Michigan or some other kind of class of people, right? I'm saying they're discriminating us, singling us out. So it's a class of 1 equal protection claim. Whether in a class of 1 equal protection claim, 3 distinct offenses, we were charged with 3 separate cases, pavers, fence, shipping containers. They have 3 court file numbers that are being simultaneously appealed should be combined for purposes of defining the class of those similarly situated. Why is this important? Let's think of it in a criminal context. Let's say that you are charged criminally with something and you believe that they are singling you out. This is something that really shouldn't be a law at all. And what's more important, though, is that they're singling you out for enforcement of this when they don't do this for anybody else. The thing is, they have charged you with 3 different things. Let's say they have charged you with, in a criminal context, I don't know. Let's say they're charging you with mail theft, stealing someone's mail. And I realize I'm mixing federal and state criminal charges here, but just roll with me for an example. Mail theft, harassment, and I don't know, speeding. And it was super speeding, so criminal charge. Like you're supposedly going, 100 miles an hour when it's a 60 mile an hour zone or something like that, okay? So 3 things. But you're simultaneously appealing them. The 3 things have nothing to do with each other. Speeding, supposedly stealing someone's mail, and supposedly harassing someone. 3 totally separate things. But they are just singling you out. They are just finding whatever they can or coming up with whatever they can to be able to single you out for action against you, right? What the circuit court judge in our case did was she waited until her final order was issued. So I had no ability to bring it back in front of her, right? I didn't know this was an issue for her. The city didn't raise this as an issue. What she did was she said, all 3 cases have to be combined for identifying similarly situated individuals. So if I want to claim that I am being treated differently from other people similarly situated, in the example I just gave you, I would have to come up with someone who is being charged with the criminal speeding, mail theft, and harassment. All 3 things. What? What does that make sense? Why would they be together? They are 3 distinct charges, 3 different court files. Just because they're being appealed together, which you can do procedurally, it saves the court's time and resources to appeal them together. That does not mean that they can be combined, because think of it this way. No one across the country would ever be able to claim that equal protection as a defense then. Because all a municipality would have to do, or a government agency or whomever, all they would have to do to stop that is grab 3 seemingly unrelated charges to charge somebody with. And then, especially the more the merrier, right? Because gosh, now we're going to charge them with not 3, we're going to charge them with 5 or 7 charges. We know that 6 of them are total bullshit, and only 1 remotely might have a chance at surviving. But this is our new strategy, because that way, if they try to claim equal protection, they're going to have to show 7 charges. They're going to have to show how somebody else, other people have been charged with the exact same 7 other things, and that they were treated differently. Or that they have they've committed those same 7 violations, and they're treated differently. You can't do it. It would make it almost impossible. That's what she did to me. She said you have to find one house that has all 7 or all 3 alleged violations. And she said I didn't do that. Now, the funny part, I did do that. She just didn't read it. The materials I submitted to the magistrate and then again to her clearly showed more than 1. I think it was 6 other properties that had all 3 violations. There were 810 violations total in a 1/4 mile radius of my house that I submitted. And 5 or 6 of them had all three categories. And it was neatly categorized and color coded. That's the color coding I'm talking about. The spreadsheet that I gave summaries of the spreadsheets, and then the spreadsheet itself, where I submitted it to the magistrate, showed the exact house, what the violation was, what category it was. Was it about the fence? Was it about the pavers? Was it about, like a shipping container? I mean, it was OCD. And I submitted all that, and she had access to that. Had she asked me for that information, had that even been something she was going to discuss, I would have clearly pointed that out to her. She wouldn't have had to dig through that evidence on her own. But she came up with this in the last hour as she was writing her final order, and I had no ability to go back in front of her and say, that's not how the law works. So, in fact, I don't know if this is a public service was still in the courtroom at this point, but he might remember that during my oral argument, when I first started talking about the constitutional issues and in fact raised equal protection, she said I could not raise constitutional issues like equal protection in the proceeding. Couldn't raise them. The only way I could raise them was to file a separate lawsuit, like a 42 USC section 1983 claim in federal court or something. That's what she literally said to me. And I bounced back on that. I was like, that's not where the case law comes from, your case law term, right? That's not where all the precedent comes from. The vast majority of precedent comes from people bringing it up in defense of charges brought against them in situations just like this one, cases just like mine, and then being appealed to the next level. So anyway, and then by the time we got to the order, then she came up with this. So hopefully that makes sense. I'll tell you the other 3, but I want to, let me see. Shoot. It scrolled. You guys had questions and it jumped again on me. Are disabled protected class of individuals? Okay, so very quick before I finish answering, this is a public services question. John Q. Public says, are disabled military or veterans a protected class of individuals as far as applied to the Equal Protection Clause? Not as far as I'm aware. Furthermore, if a disabled military or veteran has their God-given inalienable Second Amendment rights to keep and bear arms deprived by a violation of the Equal Protection Clause. I don't know what your question is. It feels like your question has the first clause of your question and not the second. Like, it has the if, but not the then. Based on the 14th Amendment right to travel, are requirements for paying a license, registration, private company? Oh, okay, that's John Q. Public. The question you asked me at 1:01 p.m., that's a whole nother ballgame. I want you to ask me that question, but maybe even save it for our next show if you can, because we could really spend a lot of time on that. And I want to fully flesh out that question. Okay, so if a judge's name shows up in the case emails, doesn't that raise a recusal issue under the appearance of impartiality rule? I feel like I'm really missing the question from We the People News. I mean, a judge's, like, for example, if I had emails on cases when I was a public defender, if I was sending an email to the judge to let him know something and I was copying the prosecuting attorney on it, the judge's name would come up in those emails if I was later on printing those and using those as evidence for something. So, but that the judge wouldn't have to recuse himself. So I feel like I'm really missing something from the question that you're actually trying to ask. Okay, so then you say, if judges and federal agents are emailing about a defendant a couple of months before that defendant was charged, isn't that ex parte communication? It depends, because are they following the proper procedures in order to have proceedings like, if it's a situation where they're gearing up to get a warrant, they need communication with the judge before there's ever a charge just to get the warrant. That would be an example. Or if they're getting stuff set up for having a grand jury to determine if there's going to be an indictment that way, that's all before the charges are filed. So it not necessarily is the answer to your question. Okay. And the quick question from Miguel, have you heard of the 1972 Article 5 reforms in Florida? It abolished municipal courts and they seem to be making a comeback. No, they're gone. So I don't know what you mean by that, but they're gone. But, okay. So to finish answering Foshin's question, question number 2, whether a homeowner may be ordered to take action that would force their property into non-compliance with local law. And really the bigger question is, can someone be ordered to do something that would violate the law? That would can you be ordered to fix a violation of one law by taking that action, it would force you to violate another law. You see what I mean? That can come up in all kinds of contexts, criminal, civil, back and forth, a mismatch of both. And that's what they did to me here. They literally ordered me to remove the stuff that is required to be there. So if I woke up tomorrow and decided, you know what, I think we should go ahead and remove our pavers, then we would be violating the city code. And I would have to violate multiple parts of the city code because the pavers are required to be there, number 1. But number 2, I'd be tearing them up without getting a permit, which they could, say that I'm violating for. And then what would they do? Issue an order saying I need to put the shit back? I mean, maybe that's a strategy I should go with. Have competing orders. One order that says I got to tear it up and another one that says I got to put it back. Anyway, whether fines and liens, this is question number 3, guys, that I posed to the United States Supreme Court, may properly be imposed when there is no alleged harm caused by an offense. This is something that a lot of you should have interest in because this is something that definitely speaks volumes far and beyond the civil context into the criminal contexts, state and federal law, local, ordinance enforcement, you name it. I'm saying, I have to put it in the form of a question, but I'm saying if there is no alleged harm, that you cannot be fined for an offense. If you have caused no harm, there can be no fine under the Constitution. If you do find someone who has committed no harm, it's excessive, which violates the 8th Amendment to the Constitution. And the 4th question, whether a never-ending daily fine is grossly disproportionate to a malum prohibitum one-time act. So, never-ending, right? This is not the only state that has those never-ending fines. They appear in a lot of other states. Sometimes the same context, sometimes not. But I'm saying it's grossly disproportionate, meaning it's unconstitutional under the 8th Amendment analysis, where it was a one-time act. How can you fine someone every single day you're adding to their daily fine when they committed an act one time? We were found guilty of installing, literally the wording was installing pavers, installing a privacy fence, installing the shipping containers without a permit. By definition, that was a one-time act. Once it was installed, it was done. It is not something that we continue to do daily. Those pavers have not come back up and gone back down. I guarantee you that. We pull weeds. That's what we do to those pavers. We sweep them. We might use the leaf blower if the neighbor's crap from their tree keeps falling on them. That's what we do to the pavers. We do not continue to install them So if it's correct to say that I should be fined for installing them, I sure as hell shouldn't be fined daily for something that was a one-time act. Especially something that's malum prohibitum. For those of you who don't know, there's malum in se and there's malum prohibitum. Malum in se, rape, murder, arson, things that are inherently wrong. You don't need a law to tell you they're wrong. Everybody just knows it. Malum prohibitum, it's only wrong because the government said so. Filing taxes. Practicing law without a license. Whatever. Concealed carrying in Michigan without a CPL. It's only wrong because the government says it's wrong. It's not inherently wrong. So those are the questions presented. The other aspect to this that you were wondering about, so I was explaining, let me see here. Eek. I was trying to tell you guys, and I see that there was another question that came in, and I'm going to answer that in just a minute, but I wanted to answer you. Okay, yes. So the first, okay. Where does this begin? Okay, so the first main thing that I point out to the court is how this case is the perfect vehicle. It's not exactly what you were asking there, Foshin, on what are the issues of national importance, but what I think is maybe even more important is telling the court and telling you guys what I've told the court about why this case is unique to get these issues to the court. And here's the thing. So first of all, this case comes from 3 separate and distinct magistrate orders. And those were done through administrative procedures. Administrative procedures all across the country are often informal, and the procedures are often very unclear for people. For example, in a Florida civil proceeding, not just administrative, but in a civil proceeding, it is the responsibility of the parties to provide their own court reporter during the proceedings if they plan to obtain a transcript. The vast majority of people don't understand that. They don't know that ahead of time. If your city is trying to bring you to a hearing for I see your I don't know how you're getting those emoji things in there, but I see the explanation points. If your municipality is trying to bring you to court, and especially in a jurisdiction like Florida, where, or anybody's bringing you to court, quite frankly, in a civil case, you go to court and whether you have an attorney or not, if somebody doesn't tell you this, you will not know that it's your responsibility as the party to bring a court reporter if you want any chance of ever filing an appeal later, because you won't be able to get a transcript if there's no court reporter. You have to hire the court reporter. It's totally unlike any other jurisdiction that I've ever been a part of. So most people don't know that, so they screw themselves over on the ability to appeal just on that alone, because you can't appeal if there's no transcript. If the court above cannot review the lower court record of what actually happened to determine if there's substantial and competent evidence to support the legal conclusions arrived at by the magistrate, then the higher court just says, sorry, you're stuck with what you got. Okay, so also, most people don't understand the importance of raising all of their legal issues and factual issues at the administrative hearing. And if they don't raise those issues, then those issues are waived. And you guys, we've talked about this many times before, but if you have any kind of hearing, whether it's a driver's license reinstatement hearing or some other kind of administrative hearing to dealing with your business or professional license, or a municipality is coming after you for something, any of those situations, any trial court level, quite frankly, but in any situation, sorry guys, give me a second here. In any of those situations, you have to bring up all of your legal and factual issues that exist right then and there. You have to bring them up at the very first time. That's your trial. If you do not properly bring up all the issues that you have at trial, most of the time you are considered as waiving those issues, and you cannot bring them up later on down the road in an appeal. Subject matter jurisdiction is one of the big exceptions to that rule. But aside from that, if you have an issue, like I'm saying it's an Eighth Amendment issue, that these are excessive fines, I've raised that with the magistrate. I raised it with the circuit court. I've raised it at every court. Most people don't do that. They wait until later on. Also, many people do not understand the right procedures for obtaining judicial review. So when you have, even if it's a regular trial court, if you're like in a district court or probate court or circuit court and you need to file an appeal, most people don't understand the process for doing that. But especially if it's an administrative hearing and you're a lot less likely to obtain an attorney, most people can't afford one or whatever. A lot of attorneys just don't practice those administrative law types of scenarios. So if you're in those administrative law hearings and you're representing yourself, you don't understand the proper procedures and what you need to do in order to have a chance to appeal, and most people wait too long. In the state of Florida, you have 30 days to file your notice of appeal. 30 days, that's it. Now, that's not your full appellate brief. The time frames for those briefs get a lot shorter the higher you go in your appellate process. But when you are doing your direct appeal, at least in the state of Florida, under Chapter 162.11 or Statute 162.11, you have 30 days to file your notice of appeal and get the ball rolling. And then once that notice of appeal is filed, then it triggers the deadlines. You got 10 days for this, and you got 30 days for this, you got 50 days for this, 60 days, and 70 days is the latest thing that's due. That's your brief on appeal. So most people don't understand those time frames, so they wait too long, and then they miss that opportunity to file an actual appeal. We did that, though. Now, what I can tell you is that, for example, in the state of Florida, Chapter 162.09, that is the statute that allowed the judge to issue the order. 162.09. If you do a basic search, just go to Google Scholar, okay? Go to Google Scholar and type in, narrow it down to Florida Courts of Appeal and Florida Supreme Court. And you look under, Florida Statute 162.09. I looked back for the last 20 years of cases that involved that statute, that even brought it up at all. There's quite a few, that don't even actually talk about the statute. They're just kind of comparing it to something, but it has nothing to do with really with the statute at all. It's just a small reference. Of all the cases where it's actually about 162.09, not a single one of them are brought up the proper procedural way that I brought the case up. That I filed the direct appeal to circuit court within 30 days under 162.11, that when that didn't work out the way that it was supposed to, I filed properly and timely a petition for writ of certiorari with the Florida Court of Appeals, whatever my words were there. But anyway, I followed all the procedures and all the steps along the way. Not a single other case that even mentions 162.09 or 0.09. That's the ability to issue these kinds of orders from municipalities for anything. Municipal orders, if you violated, like your dog was off the leash, or you have a nuisance or blight, or whatever the case is. Every single one of them have to go through this process. And not a single case in the last 20 years was done through this process because people don't know about it. So this case presents a very unique opportunity for these litigants, everyday people who have not been able to fight back otherwise, to have a real opportunity to fight back and have some of these issues heard. Now, you might be wondering, what are those cases? How are they bringing them to court then? How are their cases in the last 20 years if they're not doing it through the proper means? Well, they're waiting until the city files a foreclosure case against them, for example. And then they're bringing up these issues. Oh, well, the fines were too excessive. Or they're filing a civil case in federal court saying, you know, hey, this was a violation of my rights when they foreclosed on my property, they took the home, they took my assets, they're trying to come after me for the rest, and it's a violation of the 8th Amendment because it's excessive fines. All of that. Those are the kinds of cases that are making it to the books on 162.09. Not a single one in at least 20 years has been the actual proper way. So anyway, this is a very unique opportunity where I've raised all the issues I needed to from the very beginning. Obviously, as the magistrate did something illegal or unconstitutional that was new, then I didn't have the chance to necessarily bring it back to him. I had to bring it to the next court. Or when the circuit court made her vastly incorrect ruling about the Equal Protection Clause, for example, that was not brought up at all, that she was going to be doing that before she issued the final order. So I could not bring that up at the trial court level, couldn't bring it up in front of her. I had to bring it up at the next court. So there's those kinds of things that happen. Anyway, so that answers that part of it. And then I will, once my case gets docketed, I'm going to put it on my website because I'm thinking that the United States Supreme Court will have a docket stamp on my document, and I want to have that official one on the website for you guys. So I will do that once it's, all docketed and up there. But anyway, you guys will be able to see why these questions are important to the average everyday person all across the country. So to finish answering Foshin's question that I started a long time ago, each part of my brief, there's a section for each of the 4 questions that says that this question is, the due process question is important. And then I explain why. This little explanation is actually only 2 sentences why. It seems really obvious that you should never be put in a catch-22. My exact words are, ordering a homeowner to take action that would force their property into noncompliance with local law violates a homeowner's right to substantive due process. This issue involves compelling implications, as no person in our nation should ever be ordered into a legal catch-22 where they are ordered to correct one law violation by committing another. So with all that being said, I think I answered that question. I'm about to melt. It is so hot in my office right now. In fact, give me guys a second. I'm going to open the window because I'm going to die. Oh. Whew. Okay, I feel a little bit better. Don't have any, until I get a call, I'm not going to put that back in. All right, so there were questions. There was a question up here. Let's see. Judge's name. I answered that one. Okay. Does an attorney or lawyer have to be barred in a certain state in order to file a federal lawsuit in another state? A barred attorney in Ohio or Indiana can file a suit in Michigan federal court. It's not even that, okay? So in order to file, if you want to file so the question is about filing a lawsuit in federal district court. Sorry guys, I am just sweating insanely here. In order to file a federal lawsuit in federal district court, you have to be licensed to practice in that federal district court. So even for me, I am admitted to practice in 2 federal district courts. There's 2 in Michigan, and I'm admitted to practice in both of them. I am not generally admitted to practice in either any of the 3 federal district courts down here in Florida. But Foshin got me admitted pro hoc vice for his case only. to, at least as standby counsel, represent him in the Middle District of Florida Federal District Court. So you have to be admitted to practice in that exact federal district court. So some states only have one. I could be wrong, but I think Minnesota only has one federal district court. I'm pretty sure South Dakota and North Dakota only have one federal district court each. California probably has 8 federal district courts. I mean, I don't know off the top of my head, but I'm guessing. So at any rate, you have to be admitted to practice in that particular federal district court. And in order to get admitted to practice in that federal district court, it's a requirement that you are admitted to practice in that state. So if I want to go get admitted to practice long term in the Middle District of Florida Federal District Court, I have to first get licensed to practice law in the state of Florida. So there's that. Integrity Now News. Can a candidate running for office delete comments from their official campaign Facebook page? Just want to know before I post something. Thanks in advance. Now I'm going to be honest here. I don't remember the 2 U.S. Supreme Court rulings that came out. I think it was a year ago. If not, it was 2 years ago. I don't even remember what the cases are. I have them printed somewhere here waiting for me to reread again. I had kind of given you guys some updates about them as they came. But there were 2 U.S. Supreme Court rulings that recently came out in the last 2 years about the issue of social media and comments and things of that nature. What I can tell you is my perspective, because I can't remember exactly what the court said about it, but what I could tell you, my perspective is that a candidate is not a public office. They're not a public official in that role as a candidate. So they can delete whatever they want. If it is if they win the election, and we're talking about, let's say, the mayor wins the election, and then he has a mayor's official Facebook page, then that's where you have issues of can they delete and what can they delete. If it's something that traditionally does not protect, like something obscene or vulgar or things of that nature, then I would say yes, they can be deleted. So, for example, if somebody, let's have an egregious example. Let's say somebody is on there trying to post as a comment on the mayor's Facebook page. They're trying to post a comment that is an inappropriate picture of a child. Yeah, that damn well better be deleted. What if somebody is trying to just comment, something irrelevant, I don't know, they're typing something out of, like a smut magazine. It has nothing to do with a federal offense, right? It's not, has nothing to do with children or anything like that. So it's a little bit lesser in degree than my first example. But it has nothing to do with the mayor. It has nothing to do with, a specific allegation or question or problem. Then they should be able to delete it. I would say if someone is on a school board member's Facebook page as a school board member, not their personal page, but a school board business Facebook page, if they should have the right to type in whatever, to quote any kind of obscene materials that is relevant. So if it's quoting from a book that's available in the public school library in that jurisdiction, and they're saying this book needs to be removed and this is the kind of material that's in it, absolutely they should be able to post that kind of material on there. I still think it should be removed as long as the book is removed. So that's kind of like a catch-22 scenario. But at any rate, but a candidate in that capacity as a candidate, That's why there are rules. There are campaign finance rules. It's not why, but it's one of the reasons why there are campaign finance rules about you have to keep once you're in office, you have to keep all of that work totally separate than your campaigning to stay reelected or campaigning for another office. You have to keep those totally separate. So there's not even the appearance of impropriety when it comes to that, because when you're a candidate, you have the right to do whatever. You can delete whatever you want. Okay. Oops. Gosh, I hate when it jumps like that. Okay. So, I'm not seeing any other questions. I find that strange. Okay. Okay. So, yeah, I didn't read a lot of the back and forth. So, Foshin, you say interesting nuance. I assume, given the timing of that comment, that it's about the distinction between when you're a public official and when you're a candidate, but I'd love to hear more from you about that. You can call in. I can give you that number if you want to do that, or just chime in here. I do need to get going pretty soon because it's been an hour and a half. I'm surprised that we actually haven't had somebody physically call yet. But, oh, and I never even, I guess I had the chat on there, just in the tiny. So I guess the moral of the story, until and if I see other questions coming in, don't give up, people. If you are legally in the right, if you have checked all the procedural boxes, like, first of all, keep informed. Make sure you have the evidence, or the receipts as people call it these days. Make sure you keep a record of everything. Make sure you do your homework and you know what the procedures are. Don't expect the government to give you that information out of either incompetence, negligence, or corruption. But don't expect them to give you the information you need. Be willing to go out, do your own research, and utilize free things. I mean, every state has available online their statutes for the public to look at. And Google Scholar is available for everyone to use for free, and you can narrow it down by jurisdiction. It's not the best search engine out there, but I tell you what, in a lot of ways, it's actually better than some of the paid ones. So, anyway. Let me see. Hold on. You guys have been... I didn't end up putting the... Yeah, I didn't put the... I mean... Somebody from Florida is calling the office line. I don't know if that's just a coincidence or not. There. I will appease you guys. What? They're calling again. I don't know what's going on with that. Anyway. Okay, so yes, nobody has called yet, but I have had the app open the whole time, and a lot of you know the phone number anyway, so yes, I haven't put it on there. Also, nobody has said in the chat that I answered all the questions that were in there, and nobody said they wanted to call, so. But John Q. Public, yes, call in during the next live stream. Oh man, it just scrolled away from your thing. Okay, you said, I do not like being a hog and calling in every time about issues here in Michigan. Okay. Well, and it's just at this point, there's, between answering the various questions, giving you guys the update, all of that stuff, it ended up taking up our time today, but, okay. Yes, that was it. If I call in, you're gonna hear heavy equipment. Okay. Okay. I'd be curious to know what First Amendment auditing you're doing in the field that requires heavy equipment to be so close to you. So I'd love to hear that. Either in the chat here, or if you want to send me a text, I'd love to hear all about it. And don't forget, you're supposed to call and invite me to something at some point along the way. Because now that I'm medically cleared to drive, you don't have to come pick me up to go with you. I can actually just meet you somewhere. I say that because that man, I couldn't have done it without him. He was one of the people that helped me get to my treatment appointments when my mom bailed on me. And my dad had to go back to work, and Mike had to go back to work. So I appreciate him like none other. Oh shoot, was somebody calling in? Hold on. I did have to, it's the same person. Hold on, we're gonna try this. I was dumb. Oh shoot.
Hello, this is Miguel.
Hi, oh hi. Yes, I forgot that I took my my earbud out, so I didn't hear when you called the correct number.
Okay.
So,
I'm sorry. I just wanted to let you know, so I'm calling out of Miami, Florida. I'm in a very similar situation as you. It's on the delay, so I've turned down the volume here. But the third DCA has a case from 2022 that I think is extremely helpful to you. And it's the Hayes v. Monroe County case. Came out in 22, had to do with code enforcement. So my big thing is, I know we're in your area. I think they honor the state constitution a little bit more than Miami-Dade County, where I'm at. Miami-Dade County has an alternative code enforcement or adjudication administrative hearing where they say they're completely exempt from statute 162. And I wanted to know your thoughts on that, because the third DCA says, no, you're not. There's two provisions to it. The first provision and then the second provision. The second provision applies. Now, in my case, they didn't honor that. And then I tried to say, okay, can we do this en banc, because there's a discrepancy here. And they just denied everything. And then my biggest issue is the Constitution of Florida protects life, liberty, property, or guarantees protections for life, liberty, and property. Yet when code enforcement comes into someone's homestead, someone's home, residence, you go before an administrative hearing, and that is the trial court. Yet it shouldn't be the trial court, which is why my thing about how these municipal courts or these mayor's courts are creeping back up, because there's no rules of civil procedure. It's like what you said, they don't tell the public the dangers of representing themselves at these administrative hearings, because they are informal. And then the county attorney who hires and fires these non-lawyer judges, they're prosecuting homeowners. They're litigating. Yet there's ordinances that say that they're the general counsel to the hearing officers. And it's so confusing. And I think more and more counties throughout the state of Florida are going to bring back these municipal courts that were abolished.
they're not bringing back, I just want to be very clear, they're not bringing back municipal courts. That's a totally different thing. Municipal courts are gone. These are a different ball game. These are administrative hearings done with magistrates, or sometimes it's a code enforcement board that you go in front of, but the statute allows for municipalities to determine in their code of ordinances whether it's going to be a magistrate or a code enforcement board that you go in front of for these. And
Right.
there is a minimum set of procedural requirements that are outlined in statutes in Chapter 162 for these proceedings. I want to say it's 162.07 that talks about that, and maybe 162.08, I believe. But yes, it's. I don't know if you've been involved in the show. You've joined us before, right? It's been a little while,
Yeah.
I think, but okay. So I don't know if you heard me before stating this, but I've stated it many, many times. Every single kind of administrative law and every single kind of administrative law judge or magistrate or any kind of administrative court, all of that is unconstitutional, because the whole point of administrative laws and administrative courts is where they are taking, they're not defining clearly in the law. The lawmakers, our state elected lawmakers, are not defining clearly what the law is. They are defining only a big outline perimeter of what the law will be, and they are then assigning to, say, in Michigan, the DNR. They're assigning the DNR the role, or MDHHS, the Department of Health and Human Services. They're allowing that agency to fill in the blanks with their rules, and then they're utilizing these rules and enforcing these rules as though they are laws. And so the same thing when you have a special magistrate or an administrative law judge or any kind of other title like that, an code enforcement board, anything like that, where they're serving in a judicial capacity. It's literally called a quasi-judicial proceeding. But anytime that they're serving in that kind of capacity and it's a quasi-judicial proceeding, we have problems because you are not having elected judges that are in those positions that are more directly accountable to the people. You are having this wishy-washy area where court procedures are not exactly the same, and it's unclear as to what they are. And it makes it also, just things like, I'll give you a very clear example of how one-sided it is. I filed a motion in the magistrate level after I partially won my first round of appeals. Partially won, partially lost. And I partially won, so I had the right to ask for costs in order for basically to have the city reimburse me the cost of all the transcripts and the court reporter fees and the filing fees, okay? And so the court rules require you to file that at the trial court level, which in this case was the magistrate. So I actually had looked up through the State Bar of Florida, because I wasn't given his email. I found his email on record, and I emailed him my pleadings, and I emailed the city attorney and the main code compliance officer involved, as well as her supervisor. And the city clerk, because she was acting as the so-called court clerk in our proceedings. So I emailed all of them. None of them replied, not one peep. They all ignored my pleadings. And when we got to a hearing later on, we had a hearing a month and a half later where the city commenced the hearing because they wanted to go get additional hearings for fines against me for the same violation, right? Which you can't do. The law does not allow them to do that. But anyway, so we were there for a second round of orders for fines. And I brought up at that hearing with the magistrate that I had motions pending. And procedurally, court rule says you cannot rule on their motions until you handle my pending motions first. Of course, he ignored that, and he's like, yeah, whatever. So he issued those orders, ignoring my motion that was pending, and said, well, you have to get a court date. And the city attorney piped up and said, we will not be giving her a court date because she's supposed to bring all that to the circuit court. No, I'm not. It's not up for the city attorney to argue a position and deny me a hearing, because it should be a neutral third party. It should be an actual court that I can file my pleadings with and request a court date from. But it's not.
Exactly right.
It's the city.
It's not. And that's why I'm afraid that, and I call them, they're quasi-judicial, but I called them, I'm titling them municipal courts because we've been here before. And even though they're calling it quasi-judicial, they're treating it the same way as these mayor's courts are treated when the voters voted for them to be abolished. But you make a great point. And the thing with these administrative hearing officers, who many of them are not attorneys, what do we do with the chevron deference that was overturned by the voters in 2016 and ratified or put into the Constitution under Article 5, Section 23, doing away with the chevron deference or the hour deference, which has to do with giving the administrative agencies or executive branch agencies or legislative branch agencies, but in this case, executive branch, the mayor's agency, deference. How do we handle that these days?
Hold on a second. You said something about amending the Constitution in 2023. That never happened.
No, 2018. I apologize if I said 2023. So in 2018, the overturning of chevron deference in the state of Florida at the voters' mandate was ratified, was put into the Constitution, and created Article 5, Section 3. That was in 2018.
Article 5, Section 23. I'm going to ask you to hold on a second. I got to take my earbuds out so I can go grab the Constitution of Florida. Hold on.
You got it.
Okay. I'm going to open it up to Florida Constitution, article. I should have this organized a little bit better, but Article 5, Section 23. In the Florida State Constitution, Article 5, Section 23.
Yes.
I don't think that's what you're thinking it is. Article 5, Section 23 is state elective executive officers and the compensation for them. It's talking about the governor, lieutenant governor, secretary of state, and attorney general.
Wait,
Oh, sorry, hold
I
on.
apologize. Go to
No,
21.
No, sorry. It's my bad. I'm looking at the Michigan Constitution. Give me a second here.
That's awesome. It happens.
I have them both in my binder, and I didn't go far enough in my... okay. Article 5, which is...
I got scared. I was like, wait.
Is the judiciary, and Section 23 is Article 5. There is no Section 23. There's no Section 21 either. I mean, there's no Section 22. Yeah, this is
What does Section 21 say? And I apologize.
well, to answer you, I would have printed this at least after I moved here. So it's no earlier than 2021 off the top of my head, I could tell you. Does this say? It does not say when I printed it, but we have not had any constitutional amendments printed. We have not had any constitutional amendments pass since I moved down here. So it's the same constitution since 2021.
Not yet. Since 2021, no. And I don't know why it's not popping up. I mean, I did do it from memory, but I've been dealing with it. And there's
I know what you're talking about.
haze
Hold on. I know what you're talking about because I actually have it underlined in here because I wanted to hammer on this myself in my own case.
Nice, yeah.
But I didn't because there are so many, I mean, they violated so many laws and court rules and even the city's own ordinances that I had to start eliminating at some point, right? So it's pretty simple. It's pretty simple for those of you who are trying to follow along at home with us. We're looking at the Florida State Constitution, Article 5, Section 21, and it's one sentence long. Judicial interpretation of statutes and rules. In interpreting a state statute or rule, a state court or an officer hearing an administrative action pursuant to general law may not defer to an administrative agency's interpretation of such a statute or rule, but must instead interpret such statute or rule de novo. That is what it says.
Correct.
And
Correct.
So
I would, if I may ask, I think the real underlying question is, does that interpretation have to be done by an officer of the court, someone who is licensed to interpret and has some weight when they interpret law and they have an opinion on the law, as opposed to a pro se litigant or a pro se person? That administrative hearing, do they have to be an officer of the court to be able to do this?
So that's not what this is getting at. This is saying that a state court, which would be circuit court, district court, whatever, a state court, or an officer hearing an administrative action, which literally can mean a special magistrate, administrative law judge, whatever. An officer hearing an action pursuant to general law may not defer to an administrative agency's interpretation of a statute or rule. So, when they're talking about, it doesn't really work about, it's not, so words matter, and this doesn't actually talk about interpreting ordinances or generally dealing with ordinance enforcement. Generally speaking, it's we're talking about like if this is most applicable in the true sense of the chevron deference kind of scenario, where if you have a state administrative agency, like an agency, I forget what in Florida, what the agency's names would be as far as like if you want to try to get back a driver's license that's been suspended, or appeal a decision that was made about your barber's license or something like that. Something to deal with agriculture or things of that nature. So administrative, for example, there is a teacher, I believe in Gainesville, who the current head of the Department of Education here in the state of Florida has said that he's initiated proceedings against her to remove her license to educate here in the state of Florida because of something she did to a student, and admits that she did to a student. And so that there, of course, the attorneys are trying to get all kinds of press and they're making it all this big deal and everything. Of course, they were going after a conservative student, and it's a liberal teacher. But anyway, so she's the victim in all of this. And so that's an administrative procedure. So and in fact, the attorneys are saying that they violated the administrative procedures on how they needed to do things in order to bring an action against her. So that's the kind of case that they're talking about. It doesn't really apply directly in scenarios where it's a ordinance enforcement scenario, if that makes sense.
It does. And so the third DCA, I don't think you're under the third DCA, but they did come out with a decision in 2022 that did reference the chevron difference, and so they said a lot of the same things that you're saying now, where there's just too much confusion in how to apply the chevron difference in any type of scenario where someone has to go before some type of magistrate or judge or hearing officer. But they never got to the crux of it. I just thought you might be interested if you haven't heard of it. The third DCA seems to be pretty powerful, but now they do have a judge that's under investigation, probably going to lose her judgeship, maybe not her license, but...
I sure as hell she's going to lose her license. Is that the blonde judge? I just saw a brief article about
Miller.
it. Yeah, something about coercing attorneys and parties through ex parte communications or text messages or something of that nature. So, didn't read the whole story.
I could be wrong. I read the same story. And I could be wrong, but I think she was one of the appellate judges in my case, because you're dealing with code enforcement essentially, from what I understand, since I've been following you. I'm dealing with code enforcement, but we're both dealing with two different areas of Florida. Miami-Dade County is its own little country, if you ask me. Things don't make sense down here. The courts don't make sense down here. Things are done down here.
I didn't say they made sense here either. I think it's all a big pile of shit all across the state.
It is. Florida's in big trouble. I'm not going to plug myself. I am a politician, so I'm going to do my part to bring this out to the public and let them know that Florida is under a crisis, in my opinion. We've always been under a crisis. We've had mayors removed by federal judges in the 90s, and then we have buildings named after them. We've had the whole restructuring of the courts in the 1960s and 70s with that 1972 reform. And it just seems like this is a pattern in Florida, where even Miami-Dade County didn't have a sheriff until this year for over 50 years, because they were drug runners. The sheriff himself in the 1970s were drug runners. So, I mean, just these crises and this corruption just seems to come back in the state of Florida, and it's incredibly concerning. And then homeowners do not get a fair trial. They don't get a jury trial. They go to these administrative hearings, and the third DCA has said, and they're contradicting themselves, but they have said that, yes, Miami-Dade County can do this. They're completely exempt from Section 162 because they have an alternative method. And it's like, when do homeowners get a fair shake in the state of Florida? at this point, because if you're dealing with it up there in a different division, and I'm dealing with it down here, and Tallahassee's doing their own thing, it's like, hello, or Lee County, you know, when I say the first district court, it's like, when are we going to have, when is the Florida Supreme Court ever going to step in and say, hey, we got to fix these things? And when are politicians going to step in and say we need to fix these things? I can do my part, but it's a high hurdle. So thank you for having your show, and thank you for informing the public of what's going on. And I'm sorry that you're going through it.
Oh, absolutely, and thank you for the kind words. Yeah, I'm gonna keep doing everything I can to fight for people, because if the United States Supreme Court eventually dockets my case and then agrees to accept to take it on, to grant my petition for writ of certiorari, this case will literally affect millions of people across the country. It'll affect people in criminal cases, but it'll absolutely affect people in municipal cases, because, you know, like the question about harm, if you haven't harmed someone, then if there's not even alleged harm, you shouldn't be fined for that. You shouldn't have liens put on your property for that.
100%.
So, you know, that's kind of where I'm at with this, and I'm hoping that it's something that you know, we have such a very small percentage of a chance that this case will ever see the light of day there, but I'm not giving up yet. I've made it this far. So
I'm proud of you. I'm proud of you as somewhat of a colleague. I'm extremely proud of you. I think there's going to be some shift happening. It's going to take some time, but I hope I get to call in again. Hopefully we get to talk about these issues and let the public know what is going on in the state of Florida in general. I can speak on my side over here because I'm entrenched deeply. I've sued the county. I've sued the mayor. I've sued the county attorney. They're doing all kinds of, they're just wiping their asses, and I apologize for cursing on your program, but they don't care about the Constitution of Florida, let alone the Constitution of the United States. They are literally doing whatever they want, and I think some of these judges are in on it because the judges don't want to deal with these issues. They just think it's beneath them, and they're allowing some unfair, you know, the points that you've brought up, the points that I've brought up, these unfair practices of judicial of adjudication to continue, and it's disheartening, and it's going to keep happening to more and more people.
right.
And finally, that's when something's going to happen. But the rest of us, we're kind of screwed.
Yeah.
In the meantime,
Yeah.
you know,
Well,
it's unfortunate.
I appreciate you calling in, and I have to wrap it up for the day, so I'm gonna have to get going. But thank you, and thank you for bringing up that part of the Constitution and asking the questions about it. It's not that it doesn't ever apply. It may very well be helpful in a case. Just I don't think in the context we were talking about would it be the most helpful is all. So, and again, I don't know the full logistics of your case either, but I know for me, it ended up being something where it wasn't as directly applicable. So it was one of the things I had to set aside in order to focus on what was, you know, most important.
Absolutely.
So,
Unfortunately, my case, because I lost, it took more freedoms away from homeowners, at least down here in the 3rd DCA. Unfortunately, I never thought that would happen. But anyway, we'll talk again soon. I appreciate you. Thank you so much. Have a wonderful day.
yes, you too. Bye.
Bye.
All right, guys. So let me see here. I have somebody coming in just a minute. Let's see. I'm going to go ahead, throw this on there. So first of all, my screen was not scrolling with the chat, so I did not see that all of you were trying to tell me the phone was ringing. I did not hear it at all, obviously. I heard my other phone line ringing, which I thought was kind of strange because that's the main line. So my bad. I knew I shouldn't have taken my earpiece out, but when I had to, I think it was when I had to open the window, I had to do that, and then whatever. My bad, guys. Thank you for trying to tell me. I didn't see that until while he was talking, and I'm like, oh, you guys were all trying to warn me. Also, I just want to be clear because I saw, again, I didn't see this chat while he and I were talking, except for at the very end there. You guys were thinking the same thing that I was, that you were thinking about the case that happened recently with the chevron deference being set aside. that he was saying the Constitution was amended and that it was at the state level and all, and we're like, you and I alike immediately were thinking, what? That is not what happened. But this is why it's good to have a back and forth dialogue and be able to ask questions, because I was able to get from him what he was really talking about, which was Article 5, Section 21 of the Florida State Constitution. That was either an amendment or at least an addition to the Constitution in 2018, which does seem to address directly the point of chevron deference at the state level, but it's just a different aspect of it than what he and I were directly dealing with. Because if you have a direct appeal from a magistrate hearing, and this is what I should have said to him, so hopefully you're still listening, Miguel. But when you have a direct appeal from a hearing in a magistrate or the code enforcement board, whatever it's called in your jurisdiction, when you have one of those hearings, and then you're filing a direct appeal under statute 162.11, it literally says right there that it's a de novo appeal, meaning that the circuit court judge has to review all the legal issues brand new. They cannot look at any of the legal issues and just rubber stamp them. They have to look at all legal issues with a brand new set of eyes. So it's already built in that way. There's no deference to an administrative agency's interpretation of anything. So it's built in that. And maybe that law was changed or modified after that constitutional provision was enacted. That's possible as well. Let's see. And I think I had gotten all of the questions. Oh, it just jumped on me. If you guys ask me questions, I apologize. I'm trying my best to... Oh, yes, good. You got I think that was 2 window decals, if I remember right. I don't remember. So I should put the plug in there. Guys, help me out, because before I moved from Michigan, I ordered 100 more pop sockets that say Restore Freedom, More Freedom, Less Government. That's a lot of money. I ordered 200, no, I have more. I think I have more than 200 of the decals, the 5x5 window decals that are about this size. And that say Restore Freedom. They have a QR code, so if you put it in your car window, people can scan it and they can see it. It comes off easy if you wanted to. It doesn't have to come off, but anyway. A business window, car window, your house window, whatever. And the 3x11 inch decals, I only have 30 of those left, but still, nonetheless, same information, just stretched out long-wise. I still have a bunch of shirts too. But really the biggest things are those 5x5. Oh, and I didn't even count them all. Oh crap. I have magnets. I have car magnets. I have lots of the 3-inch by 24-inch that say Restore Freedom, More Freedom, Less Government, with the QR code that people can scan and get right to the website, get all kinds of information for free. And so anyway, if you guys help me out, send a donation at least to cover the cost of the shipping so I can mail these to you. Help me out, get this stuff out there to spread the word no matter where you are in the country. It would mean a lot to me if you guys purchased one of those, 2 of those, 10 of those, give them out for Christmas, stocking stuffers or whatever. It would mean a lot. I mean, the pop socket, it has a function all of its own, right? It's useful regardless of your political stance. So anyway, Jay Kerford, I'm glad that you got your package in the mail. And I ask for those, the rest of you to consider getting 1 or 2 or 10 of those items. And if you contact me directly, and if you want multiples, now that Square kicked me off for being a conservative, I was with them for like 15 years. I've had Square as a credit card processor longer than I've had my husband as a husband. And we've been together 14 years. So anyway, when Square kicked me out last year for being a conservative, I no longer have the ability to tweak and change things as easily as I did before with quantities and things like that. So if you contact me directly and you're like, hey, I would like 10 car magnets or 10 pop sockets or 10 whatever, obviously if I'm shipping them all to the same place, the cost of shipping is drastically reduced per item, and I will just pass along that savings to you if you order it that way directly. Just shoot me an email. Contact@restorefreedomkh.com. I would love to be able to work with you just to get the stuff out there. So anyway, so I'm just double checking. It just scrolled again. I am so sorry, guys. If you guys had a question and it skipped on me, then I apologize. Okay. So, yeah, shirts are not on there because, again, they were on there when I had Square, and now it's like a totally different thing. So if you guys want shirts, I have size medium, large, and extra large available. And they're in a unisex cut. They're not female cut. I have black in all sizes. And in the 2 larger sizes, I have gray. And they either say Restore Freedom with Catherine Henry, or they just say Restore Freedom, but they all say More Freedom, Less Government. And then I also have a yellow, a light blue, a salmon, light salmon color, maybe 2 yellows. I can't see from here. I just reorganized my closet in the last few days. Mike built me some shelves in there so I can actually see the items I'm talking about. It's awesome. I love organization. Anyway, so I only have like 1 of each of those. So the amount of time it would take me to like put all that on there, it was gonna like it's not the same and is not as easy as when I had Square. So if you want a shirt, please let me know. They are very soft. I made sure to get very soft, high quality stuff. So just let me know. Just shoot me an email and we'll talk about it. And that way I could get your shipping address and we could figure out how to do it and all that. So anyway, again, I have medium, large, and extra large. All right, I think I got all of your questions, comments, concerns. Oh my gosh, yes, I would love to work on ending property tax. I also have a bill I want to implement or get worked on that would drastically reduce homeowners insurance in the state of Florida, but that's a whole nother topic. So anyway, yes. Yes, email me if you want some shirts or any of the stuff. If you don't see it online, anything that I mentioned, you can send me an email and we'll get it figured out that way. So thanks so much for joining me, guys, today. I really appreciate it. Keep the prayers coming because this case is nowhere near over. I mean, the hurdles above me are still very large, in fact, and I need all the prayer that I can get, all the divine intervention that I can get. So thanks so much, everyone. I hope you all have a wonderful day.
Our work to restore freedom would not be possible without support from people just like you. From the various software and hardware needed to the legal research materials, every dollar you can donate helps. Make sure to like and share this video too. And remember to follow and subscribe and click that notification button. Together, we